relating to attempted suicide or self-harm, presents an opportunity for the city to set expectations regarding the unique skill sets and roles of MPD and BCR. MEC must ensure training, call scripts, and protocols are updated to dispatch BCR where appropriate. 3. Training on behavioral health issues does not equip officers to respond appropriately if we don't deal with the crazy naked guy, who will. It's not the old days. Can't lasso them. Best way to deal with them is to put them on the ground and handcuff them. And police are the only ones who are justified in doing that. I don't know a better way. MPD officer during ride-along with DOJ investigator, July 2021. Our investigation showed that a law enforcement-led response can cause real harm in the form of trauma, injury, and death to people experiencing behavioral health issues, as well as other impacts. These harms may be avoided by dispatching behavioral health responders rather than law enforcement where appropriate, and they can be mitigated by sending behavioral health responders with police where a law enforcement response is needed, as well as by appropriate training of law enforcement officers. Officers will inevitably come into contact with people experiencing behavioral health issues and, as a result, they must be prepared to interact appropriately with them. MPD's training in this area, however, is at best inadequate, at worst, it is factually inaccurate and biased. While we observed encounters in which some officers displayed compassion and kindness for people with behavioral health needs, the training may contribute to prejudice among MPD officers against people with behavioral health issues. Since at least 2017, all MPD officers have received Basic Crisis Intervention Team (CIT) training, but the training program suffers from serious flaws. Training materials contained concerning messaging, including inaccurate medical information. One MPD crisis intervention trainer told trainees that responding to behavioral health calls could be dangerous because they think you're coming to rob them. Likewise, training materials provided by outside consultants on behavioral issues among youth were problematic. A slide on autism stated that a child with a condition will power struggle with you to the death. Also unclear are what quality standards, competency requirements, or monitoring apply to the curriculum or trainers as part of MPD CIT and other behavioral health related trainings. Our investigation shows that current training is not sufficient to educate officers about behavioral health issues, with officers underestimating the need for training at all. One officer told us he did not need training to know someone is off their rocker. And despite a laudable city directive to stop training officers on excited delirium, training given to MPD officers referred to severe agitation with confusion, delirium, in an obvious attempt to skirt the city directive. Some officers continued to mention excited delirium in call comments and reports. 81 This reflects the importance of confirming the quality and accuracy of training before it is delivered and the need for proper oversight following trainings. 4. The city and MPD can make reasonable modifications to avoid discrimination against people with behavioral health disabilities. The ADA requires public entities to make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the service, program, or activity. 82 Whether a particular modification is reasonable and not a fundamental alteration includes a fact-based assessment of a particular jurisdiction. Expand and improve BCR as an alternative response. BCR is an important step toward creating a meaningful alternative to police for calls involving behavioral health issues. Resources in sufficient quality and quantity are critical to its ability to provide appropriate services and prevent unnecessary police responses. Increased collaboration and coordination with other city and county programs can further enhance BCR's efficacy. Deeper connection between BCR and other first responders and providers, particularly COPE, as well as the recently launched 988 Suicide and Crisis Lifeline, is essential. Minneapolis' network of mental health treatment and support resources is largely untapped given the city's current siloed approach. Modify MEC to dispatch an alternative response where appropriate. MEC must also ensure accurate identification of and responses to behavioral health calls and engage in robust quality assurance. City policies must better delineate the responsibilities of MPD, BCR, and other first responders in behavioral health calls, including joint responses involving more than one agency, so that MEC can accurately 81 in light of the well-documented connection of the use of excited delirium to racial bias. The persistent presence of this concept is troubling. C. Brooks, Myrick Walsh, Isaac K. Agbula, Edward Cupit, Jr., John S. Rosell, Ambrose H. Wong, Revisiting Excited Delirium, Does the Diagnosis Reflect and Promote Racial Bias? 24-2 Western Journal of Emergency Medicine 152-59, March 2023, electronically published January 31, 2023. 8228 CFR Section 35.130b, 7. The city need not provide a reasonable modification if the person requiring the modification poses a direct threat to the safety of an officer or others. See 28 CFR Section 35.139a. A direct threat is a significant risk to the health or safety of others that cannot be eliminated by a modification of policies, practices, or procedures, or by the provision of auxiliary aids or services. 28 CFR Section 35.104. Assess calls for service and deploy the right responders in accordance with the unique missions and skill sets of MPD, BCR, EMS, and Fire. Ensure quality and impact of MPD behavioral health training. MPD can make changes to its CIT program to ensure that when calls related to behavioral health do need a police response, appropriately trained officers respond. Training related to behavioral health issues must ensure that when MPD officers respond to situations in which behavioral health issues are present, they do so appropriately. It is critically important that behavioral health related training for MPD, including cross-training with BCR, be updated, accurate, and impactful. Expanding BCR to ensure that the city can provide services tailored to residents with diverse behavioral health needs holds much promise. As Mayor Freight told us, being able to have someone show up without a gun and with the right skill set is critical. Coordination and continuous assessment will be essential in this next phase to make sure all people in Minneapolis receive appropriate responses when they call for help. Contributing causes of violations. A. MPD's accountability system contributes to legal violations. Effective police accountability requires timely, thorough, and objective investigations into alleged officer misconduct, as well as meaningful discipline. People deserve to have their misconduct complaint investigated fairly. Community trust in law enforcement suffers when officer misconduct is tolerated. MPD's accountability system is fundamentally flawed. 83 It consistently fails at its core purpose, to find, address, and prevent officer misconduct. Instead of a clear, straightforward accountability system, MPD's system is an opaque maze, with multiple dead ends where meritorious complaints are dismissed without investigation and often for no discernible reason. Significant allegations and complaints are mischaracterized or ignored. Officers who commit serious misconduct are diverted to coaching or retraining, and sometimes, the coaching or retraining never happens. If MPD does investigate a complaint, obvious misconduct is often overlooked or excused. By the end, the investigation often has taken so long that the complaint becomes stale, leaving problematic officers to continue committing misconduct for years. To investigate MPD's accountability system, we conducted dozens of interviews of city leaders, union officials, Office of Police Conduct Review, OPCR, staff, MPD command, civilian police conduct, review panelists, and community members. We studied a random sample of over 400 complaints that the OPCR closed after 2016. We focused on closed cases to account for the inordinate delays in processing complaints, particularly those placed into investigation. Indeed, of OPCR cases opened after 2016 and placed into investigation, 53.1% remain unresolved for at least 1 year, and 26.1% remain unresolved for at least 2 years. To ensure we could evaluate complaints from beginning to end, we assessed MPD's performance when resolving cases during our review period, regardless of when the alleged misconduct occurred. Our case review 83 on December 14, 2022, the city amended provisions of the Minneapolis Code of Ordinances that relate to police conduct oversight, effective April 2023. Pursuant to these amendments, MPD and the Minneapolis Department of Civil Rights adopted a revised police misconduct complaint process manual on April 20, 2023, that will govern how complaints of police misconduct will be allocated, investigated, and processed by the two departments. See Minneapolis Code of Ordinances Section 172.30, amended December 14, 2022, Ordinance Number 2022-058. https://mclibraryfunctions.user-websites.us/api/ordinance download/11490/1190830/pdf https://perma.cc/53bnhgz9. The revised manual identifies a transitional period to effectuate these new policies that concludes 120 days after the effective date of a settlement agreement between the city and the Minnesota Department of Human Rights. As a result, this report details our review of the city's accountability systems prior to the enactment of ordinance amendments in late 2022, and revised policies in April 2023. Included a random sample of approximately 80 OPCR complaints that were placed into investigation, as well as complaints dismissed or diverted on various grounds, for example, no basis, no jurisdiction, failing to state a claim, or referred to coaching. We also reviewed OPCR complaint files related to conduct we learned of through community outreach, news reports, interviews, and other documents. 84 MPD officers' misconduct costs the city dearly. Between 2018 and 2022, the city paid out $61,502,925 to settle claims of police misconduct. Apart from the $47 million in settlements for the deaths of Justine Rustzik and George Floyd, the city paid $14,502,925 for 69 claims, or lawsuits from 2018 through 2022. In April 2023, the city approved additional settlements of $7.5 million and $1.375 million for misconduct related to arrests by Derek Chauvin occurring in 2017. In May 2023, the city approved a settlement of $700,000 related to the allegedly unlawful detention of 3 children while their father was killed during a police shooting. Sometimes, MPD pays for the repeated misconduct of certain officers. For instance, MPD paid $344,000 to settle claims related to one officer's uses of force over a 12-year MPD career. This includes settlements of $140,000, $82,000, and $62,500 for the officer allegedly choking an 18-year-old developmentally disabled student unconscious, punching a woman in the face and knocking her unconscious, and beating a man unconscious outside of a bar. Our review shows that MPD frequently fails to address police misconduct, which allows officers serious violations of people's rights to go unpunished. MPD's flawed accountability system contributes to the unconstitutional and unlawful patterns or practices we found. 84 As noted above, we evaluated OPCR's handling of misconduct complaints for those complaints where the resolution fell within our review period, beginning in 2016. It is not possible to fully assess how a complaint is processed and investigated until the complaint investigation is completed and the officer has exhausted appeals and other rights. As a result, our sample includes cases that were filed before 2016. Nevertheless, the older complaints suffer from the same deficiencies that we highlight regarding the more recent complaints in our sample, and these deficiencies are contributing causes of the violations of federal law. Case study: far outside the norm. In 2014, an MPD officer responded to a report that a man had committed retail theft. The OPCR investigator noted that store surveillance video showed the officer punching the man multiple times in the face with a closed fist while the man is handcuffed behind his back. The force review supervisor completed the force review without viewing the surveillance footage that would have revealed the misconduct, and MPD did not investigate further at the time. The officer continued working and continued using unreasonable force. He had 8 uses of force requiring the supervisory force review from March 31, 2016, to May 30, 2016. In one of those incidents, the officer kicked a man in the face after the man was already on his hands and knees. The man suffered a traumatic brain injury and a displaced nasal bone. MPD settled with the man for $150,000, and the officer was convicted of assault. MPD's 2016 internal review of the officer's force shows that from February 2012 to June 2016, he had 68 force incidents, a number that OPCR noted was far outside the norm for an MPD officer. 1. The complexity of MPD's accountability system discourages complaints and prompts their dismissals. Minneapolis has a combined civilian and MPD internal accountability system to review and process allegations of police misconduct. This consists of MPD Internal Affairs, IA, and OPCR. OPCR handled the overwhelming majority of complaints during our review period. IA may have handled a complaint alone or jointly with OPCR. 85 During our review period, the commander of IA and director of OPCR, collectively the joint supervisors, together processed every complaint of police misconduct within OPCR's subject matter jurisdiction. 86 The joint supervisors could decide to dismiss a 85 For simplicity, we use MPD to refer collectively to actions and investigations of MPD internal affairs, the joint supervisors, and OPCR. 86 To fall within OPCR's jurisdiction before the December 14, 2022, amendment. A complaint must have been filed within 270 days of the misconduct and allege excessive use of force, inappropriate language or attitude, harassment, discrimination in the provision of police services, theft, failure to provide adequate or timely police protection, retaliation, or criminal misconduct. Minneapolis Code of Ordinances Section 172.20 Complaint on the merits, referred to as no basis, for a lack of jurisdiction, or for failure to state a claim, among other reasons. The joint supervisors could also refer it for coaching of the officer, or for formal investigation. After a complaint was investigated, the joint supervisors decided whether to dismiss it on the merits or refer it for review by a panel of MPD and civilian panelists for a merit or no merit recommendation to the chief of police. MPD's accountability system has been needlessly complex. A complaint traveled through numerous steps before the MPD chief of police could issue a final decision and potential discipline. We found several opportunities to dismiss or divert a complaint before it reached the MPD chief. During our investigation, MPD produced an 8-page flowchart that illustrates the number of steps, decision points, and mandatory delays built into the accountability process. In one case we reviewed, an MPD investigator discouraged a man from pursuing a complaint based on the complexity of the system itself. The man filed a complaint in 2013 alleging that he was in an altercation at a bar and was escorted out. He stated that he was compliant and walking away from bar security when an MPD officer reached around his shoulder and sprayed him in the eyes with pepper spray. When we spoke to the man, he said the MPD sergeant assigned to investigate the complaint had said the process would take a lot of time, he would have to show up in court, and there would likely not be a consequence for the officer. In March 2016, OPCR dismissed the complaint as failure to cooperate. The man told us he would have pursued the matter had he believed the officer would face consequences. MPD wrongfully dismisses complaints at intake. By city ordinance, MPD must assess and review every OPCR complaint at intake. Before the recent amendments to Minneapolis law, complaints could only be dismissed during intake if the complaint failed to allege a violation on its face or for lack of jurisdiction. Although MPD could refer lower-level complaints, for example, improper attire, appearance, failure to properly inspect vehicle, for coaching, the law required that other qualifying complaints shall be formally investigated. Nevertheless, over the time period of our review, MPD investigated only 13.6% of the non-duplicate complaints OPCR received. 87 At intake, MPD dismissed approximately 65.7% of misconduct complaints, which included 19.8% of the complaints on the merits, repealed per December 14, 2022 amendment. IA handled police misconduct complaints filed outside of the 270-day window and complaints against civilian employees. 87 Nearly 23% of all OPCR complaints were dismissed as duplicates, without any investigation, and referred 18.3% of the complaints for coaching in lieu of a formal investigation. A dismissal at intake can occur even when the misconduct is captured on video. For example, MPD dismissed as no basis a 2019 complaint involving clear policy violations captured on body-worn camera. The complainant saw officers breaking up a party at her neighbor's home. She stated in her complaint that officers used profanity and one officer repeatedly shoved a young person in the chest. Body-worn camera footage confirms her account. An officer can be seen pushing a young person down the street. Another officer stated, "Pull your pants up, boy. It's disrespectful to show your ass. You know what that actually means in prison." That same officer used profanity as well, saying, "A fucking move, get the fuck out, right fuck me, right get the fuck out of here." The dismissal does not mention the shoving or the profanity, which are both policy violations. We learned of an instance when MPD dismissed a complaint as no basis and suggested to the complainant that there was an investigation when there was none. In 2018, MPD dismissed a man's complaint of unlawful detention. He alleged that officers detained him for 6 hours, took his money, took his motorcycle, strip searched him more than one time, and took DNA swabs. Finding nothing, the officers did not arrest him. The man said in his complaint that he felt violated. The OPCR file does not reflect any investigation or provide an explanation for the dismissal. Nevertheless, MPD advised the complainant that an appropriate investigation took place. Even when an officer's misconduct potentially injures someone, MPD may not investigate. When an unarmed man said he was planning to file a complaint, an MPD officer pushed him backward so hard his head struck the sidewalk. The officer searched and handcuffed the man, who remained compliant and seated as he waited for EMS to respond. MPD did not investigate whether the use of force was retaliatory or excessive. Rather, MPD referred the officer for non-disciplinary training. MPD even declined to investigate a May 2018 case of serious force referred to it by the Minneapolis city attorney. The referral included a video taken by a city worker that shows an MPD officer placing his knee and full body weight on an arrestee's head and neck area. The video also depicts a concerned community member walking up to the officers and stating, "He sir, treat him with respect." MPD received the complaint and video on July 5, 2018. Either due to MPD failing to timely refer the complaint to OPCR or OPCR failing to timely log in the complaint, MPD erroneously dismissed the complaint in October 2019 for lack of jurisdiction. B. MPD misclassifies complaints and ignores explicit misconduct allegations. MPD frequently misclassifies complaints and fails to identify obvious misconduct that should trigger an investigation. This tends to occur when MPD identifies only a subset of a complainant's allegations for investigation or substitutes its own allegations for the complainant's, thereby distorting the complaint. The result is that the specific allegations that most troubled the complainant, often involving severe misconduct, are dismissed without the complainant's knowledge. Indeed, MPD does not document any notice to complainants of what allegations will proceed through the intake process. In one incident, a woman alleged that 2 officers failed to take action against a dangerous driver, but MPD ignored her allegations. The woman called MPD about a man with a smashed car, broken headlights, front bumper missing, who'd been blocking visibility from windshield, and smoke coming from the engine. She said that officers did not appear to conduct the sobriety test, but instead told the man to move his car out of the street. When he did so, he drove it into a parked car. The officers then let the man drive away. She wrote that the officers' actions made her fear for my safety and the safety of others. The form that documents coaching referrals has a space for complainant's description of employees' action, and the form identifies a violation of MPD's body-worn camera policy. The form is silent about the officer's dereliction of duty. At times, MPD bypasses the allegations that seem most upsetting to the complainant. For example, in 2020, after a black woman called 911 seeking help for her white partner, who was experiencing a mental health crisis, officers forced entry into the house, arrested the black woman on suspicion of domestic abuse, and transported the white woman for a mental health examination. Officers held the black woman overnight, even after the white woman, who had been holding a butcher knife when officers arrived, subsequently admitted to an officer on scene that she was the physical aggressor. When the black woman later filed a complaint alleging discrimination and unlawful detention, the city and MPD did not process, let alone investigate, her allegations of discriminatory policing and unlawful detention. Instead, 8 months later, it was handled as relating only to body camera usage in professional policing, and the officers were referred for coaching. As another example, A different black woman alleged in 2019 that she and her fiancé experienced an unlawful search, discriminatory policing, and use of excessive force. She alleged that MPD officers came to her home to investigate domestic violence, which she denied. She claimed they beat on her door, used profanity, entered her home without consent, and drew their firearms and tasers. They then pushed her fiancé into a wall, handcuffed him, and conducted a warrantless search of her home without permission while her 3-year-old child watched. Body-worn camera footage confirms her account, including an officer shouting, "Open the fucking door and I will kick this fucking door in." The woman sued, and a federal court held that the officers were not entitled to qualified immunity, granted plaintiff's motion for summary judgment, and found the officers liable for an unlawful search. The court noted that, this was a highly charged situation, due mainly to the officers' aggressive manner. If anything, the plaintiffs were the ones who remained as calm as possible, throughout the interaction with the officers escalating the situation. Despite the unlawful and degrading treatment of the family, MPD did not address the allegations of an unlawful search. Instead, MPD focused only on whether the officers violated MPD policy by failing to completely investigate potential domestic abuse, and whether one officer engaged in unprofessional policing. After a preliminary investigation, MPD found no violation of the MPD domestic abuse policy and referred one officer for coaching for use of profanity. C. MPD diverts complaints involving serious misconduct for coaching, and the coaching may never happen. MPD has used coaching as a non-disciplinary corrective action tool to address low-level misconduct. Low-level misconduct includes infractions such as improper attire or appearance, and failure to properly inspect a vehicle. Most coaching referrals occur at intake. At that point, the officer's supervisor would investigate the alleged misconduct, decide whether the officer violated MPD policy, and provide coaching. Fewer than 1 in 4 OPCR complaints referred for coaching at intake actually resulted in coaching. We found that MPD refers for coaching many allegations that are far from low level. For instance, MPD referred for coaching a 2019 complaint that alleged an officer smacked, kicked, and used a taser on a teen accused of shoplifting. The video showed egregious misconduct. The officer failed to de-escalate, used excessive force, called the teen a motherfucker, conducted a custodial interrogation without Miranda warnings, and questioned him after he asked to speak with his mother. The complaint file does not indicate whether the officer's supervisor investigated the incident or coached the officer. MPD dismissed the case 1 year later with the designation reckoning period expired. In another example, MPD improperly referred an officer for coaching after he detained a group of people at a Starbucks about a missing $5 bill. A customer told the MPD officer that he dropped the money and an unidentified youth picked it up. The officer then confronted a girl, who said she did not have the money and that the customer had been sexually harassing her. The officer detained 8 other people, many of them minors, and arrested the girl, even though someone had offered to reimburse the customer. A man used his phone to photograph the officer's badge number, and the officer knocked the phone to the ground, breaking it. The officer released the girl after a bystander gave $5 to the customer. At intake, MPD referred the complaint for coaching. There appears to be little follow-up to ensure that recommended coaching ever happens. In one case, an investigation revealed that an MPD sergeant used her personal cell phone to communicate with a sexual assault survivor, a policy violation, and inadvertently sent a picture of a partially unclothed man. The survivor filed a complaint, and the sergeant was referred for coaching. There is no indication that the coaching occurred, and MPD dismissed the complaint 4 years later with a designation of reckoning period expired. We also found inexplicable delays in follow-through when officers are recommended for coaching. According to OPCR staff, the coaching process is expected to be completed within 45 days of the referral. However, we reviewed case files where coaching documents were not completed for up to almost 2 years after the OPCR complaint was filed. 2. MPD fails to conduct thorough, timely, and fair misconduct investigations. When MPD does investigate a complaint, the investigations often skip key investigative steps and are significantly delayed. Complaints languish for no legitimate reason, sometimes for years. Under OPCR policy, investigators delay interviewing involved officers, if they interview officers at all. Open investigations are abruptly closed and dismissed with designations of reckoning period expired, failure to cooperate, and no basis. Case files often do not contain documentation explaining the basis for these dismissals, which sometimes appear to reflect the length of the delay itself rather than a decision on the merits. Investigations of MPD officer misconduct, even serious misconduct, are inexcusably slow. We reviewed the OPCR database to determine how long complaints opened and placed into investigation remain open. We found significant delays. 92.2% of cases remained unresolved, at least 90 days. 87.7% of cases remained unresolved at least 120 days. 78.5% of cases remained unresolved at least 180 days. 53.1% of cases remained unresolved at least 1 year. 26.1% of cases remain unresolved at least 2 years. Lengthy delays undermine efforts to hold officers accountable for misconduct. A commander told us that discipline takes way too long. That is a huge problem, here. A union leader pointed out that lengthy delays in imposing discipline benefit the officer, who can argue that the misconduct couldn't have been that serious if the department waited so long to act. We found several files in which it appears there was no investigation at all. For instance, in 2019, MPD dismissed a timely 2-year-old complaint that alleged an officer used excessive force by shoving and pepper spraying a person who was retreating. The investigator never interviewed the complainant, witnesses, or the officer. Nevertheless, MPD closed it as reckoning period expired, an improper basis for dismissing a timely complaint. If there is an investigation, it often omits obvious and essential steps. For instance, MPD dismissed a timely complaint that an unidentified officer used excessive force at a barbecue. One witness saw an officer kick a compliant man in the back of the leg, drop him to the ground, and knee the man's spine, and saw another officer kick dirt toward the man's face. Another witness reported that officers kicked the man in the gut and shoved his face in the dirt. The investigator did not interview any of the 8 officers who were at the scene. Instead, the investigator recommended dismissal because this case has passed the reckoning period during which any potential action could be taken against any of the involved officers. MPD dismissed a complaint on the merits over 2 years after it was filed. We also found investigations in which the investigator's conclusion bore little resemblance to what actually occurred. In 2017, an MPD officer threw an intoxicated woman to the sidewalk for jaywalking. Video footage shows the officer after he exited his vehicle and followed the woman down a busy sidewalk after she had crossed against the light. The officer grabbed her arms from behind and stated, "Stop. You're under arrest." She turned toward him and said, "Huh?" The officer replied, "You play stupid games, you get stupid prizes," as he pulled her arms behind her back. She said, "What do you mean?" while turning toward him. The officer then yelled "Stop," and threw her down, slamming her face into the curb. The investigator never interviewed the officer. Nevertheless, he concluded that the woman attempted to evade the officer by speeding up, and resisted the officer by saying, "No." None of that is captured on the body-worn camera footage. MPD dismissed a complaint and referred the officer for non-disciplinary training. In the woman's federal lawsuit, the court denied the officer qualified immunity. The court concluded that a reasonable jury could find that the woman was not attempting to flee or resisting arrest, but confused and perhaps trying to pull away from someone she thought was attacking her from behind. 91 Investigators also tend to draw inferences in favor of officers that the evidence does not support. As discussed on page 13, 2 officers responded to a home security system false alarm. While one officer went to the front door, the second officer scaled a 6-foot privacy fence and shot the resident's 2 dogs. The dog's owner sued, and the United States Court of Appeals for the 8th Circuit affirmed both the district court's refusal to grant qualified immunity to the officer and the district court's denial of defendant's motion to dismiss plaintiff's unlawful seizure claim. The appellate court concluded that the video evidence was not entirely inconsistent with the complaint, which described the first dog as walking toward the officer, wagging his tail in a friendly manner to greet him, just before he was shot, and the second dog as presenting himself in a non-threatening manner. 92 The investigators saw things differently. Without interviewing the officers, the investigator agreed with the officer's threat assessment. The investigator wrote, "Both dogs ran towards him. The first dog growled at him. Growling is an indicator a dog may bite. The body-worn camera footage had no sound when the officer shot the first dog, and there is no indication of the second dog growling. MPD referred the shooting officer for non-disciplinary training and paid $150,000 to settle the lawsuit. 91 Gaines v. City of Minneapolis, number 18838, 2019 U.S. Dist. Lexus 221596, at 8, D. Minnesota December 26, 2019. 90 Toolme v. Mays, 18F.4th 283, 286, 8th Sir. 2021. 3. MPD fails to adequately discipline police misconduct after investigation. The joint supervisors could dismiss complaints or approve them to be presented to a police conduct review panel, a group of civilian and sworn panelists who make recommendations to the chief of police on whether a complaint has merit. Between 2015 and 2020, approximately 37.3% of complaints originally referred for investigation were ultimately presented to a police conduct review panel. Discipline for MPD officer misconduct is rare. Between 2016 and 2021, approximately 2.9% of non-duplicate OPCR complaints resulted in a letter of reprimand, suspension, demotion, or termination. When limited to non-duplicate complaints that OPCR deemed to state a claim within its jurisdiction, this figure is approximately 4.2%. Even when officers admit policy violations, they may not be held accountable. For example, someone turned in a teenager's lost wallet at an MPD precinct front desk. When the teen's mother came to retrieve the wallet, it was gone. During an MPD investigation, the desk officer admitted that he had failed to inventory and secure the wallet. Nevertheless, MPD dismissed a complaint as no basis, and never presented the investigation to a police conduct review panel. Even though MPD knew the name of the desk sergeant, someone crossed out the name in the investigative file and replaced it with unknown officer. Official OPCR complaint form, unknown officer or review also showed inconsistent practices with respect to review panel referrals. In some instances, MPD refers only a portion of allegations in a complaint, and frequently without explanation. MPD advised at least one complainant that a review panel found no merit to her complaint, but there is no record in the case file that a panel review ever occurred. OPCR also does not ensure that panelists collectively review and follow all instructions when deliberating. For example, panelists are instructed during their training that they must consider only evidence contained in the investigative file, and may not base conclusions on information regarding the matter or the persons involved if that information is not part of the investigative file. Nevertheless, civilian panelists told us that during deliberations, MPD sworn panelists sometimes provide character evaluations of the subject officer, describe the physical location of the event, explain MPD policies at issue, and provide insight on the law enforcement response. This structure provides sworn panelists considerable opportunity to influence a panel's merit or no merit recommendation. If the chief of police does issue discipline, the discipline may be reversed. Post-discipline arbitration often overturns discipline determinations. As discussed on page 46, in 2019, the former chief terminated 2 officers for racially derogatory and offensive decoration of a Christmas tree in the 4th Precinct. In October 2020, the arbitrator vacated one officer's termination, and imposed a 320-hour unpaid suspension. The other officer settled with a medical retirement after filing his grievance. Case study: 11-count indictment. MPD allowed an officer to remain on active duty status for 2 years after it learned that he was conducting potentially illegal searches and seizures. In October 2017, the officer pulled a suspected hit-and-run driver out of her vehicle, then improperly searched the vehicle, including opening and reading letters he took from the glove box and center console. In November 2018, MPD found the officer was overly aggressive and very disrespectful, conducted an improper search, and failed to document the search. MPD let the officer continue working, and he continued his unlawful behavior. He accumulated 10 complaints over 2 years, including allegations of harassment, unlawful arrest, unlawful search and seizure, and excessive force. For example, in July 2019, The officer removed a man and his 5-year-old daughter from their vehicle and unlawfully searched it in a store parking lot. MPD did not suspend the officer until October 2019. The lack of timely adjudication of the 2017 misconduct case permitted the officer to engage in a continuing pattern of constitutional violations, resulting in the officer ultimately being charged in a November 2020 11-count federal indictment. In November 2021, the officer was convicted in federal court of abusing his position from September 2017 through October 2019 to obtain controlled substances for his own use by deception and conducting unconstitutional searches and seizures. MPD's failure to investigate and address officer misconduct has taken a toll on community trust. People in Minneapolis have reason to question whether making a complaint to MPD was worth the trouble. Our investigation found that all too often, it wasn't. B. MPD's training does not ensure effective, constitutional policing. Our investigation uncovered systemic deficiencies in MPD's training programs that contribute to the pattern or practice of violations we found. We identified a wide range of problems across MPD's recruit, in-service, and field training programs, including the qualifications of instructors, poor training materials, and chronic understaffing at the training division. These problems have plagued MPD for several years, resulting in deficient and inadequate training. For example, officers and supervisors alike told us that they were confused after MPD changed its use of force policy. We found numerous problems with the way MPD delivers training to officers. Instructors do not have formal training certifications, and MPD has not established criteria for selecting instructors or implemented mechanisms to evaluate how well instructors are performing. We found that many members in the training division lacked an understanding of best training practices and did not have strong training skills. Training materials generally fail to succinctly identify learning objectives and state what performance criteria would be used, making it difficult to assess what skills were taught and what students learned. City and MPD leaders were candid in their assessment of MPD's training programs, saying, "We have had a lot of problems." Our review of MPD's training also revealed an over-reliance on using force during encounters. We found that MPD staff favored training on defensive tactics over training on de-escalation options. We also found that MPD provided insufficient opportunities for scenario-based training so officers could practice de-escalating stressful encounters and avoiding the need to use force. We paid particular attention to MPD's field training program. A new officer's first few months in the field are where they learn agency culture. A top city official told us, "If the first thing an officer hears on the street is forget what you just learned, I'll tell you how to be a cop." That screws up everything we just did. When MPD recruits graduate from the academy, they enter 5 months of field training where they are paired with a field training officer, FTO. The FTO should regularly evaluate the new officer. And MPD should regularly evaluate the performance of the FTO. FTOs must model MPD values and ethical conduct, and officers with poor skills or poor disciplinary histories should not serve as FTOs. Allowing unsuitable officers to serve as FTOs risks spreading bad tactics and bad attitudes throughout the agency. MPD officers and training staff expressed a wide variety of concerns about the FTO program. An FTO told us that MPD was using inexperienced FTOs, and somebody who only has 1 to 2 years on the job should not be an FTO. There is a lack of consistency between FTOs. One FTO wrote that the biggest challenge of being an FTO is watching other FTOs, who suck at their job, train a recruit, who now will pass, and suck at their job. We are aware of officers serving as FTOs even while under investigation for serious misconduct. For example, one officer served as an FTO following a 2016 incident in which he punched a handcuffed man in the face multiple times. While the incident was being investigated, he told us, he was initially suspended without pay, then brought back, first to limited duty then to patrol, where he served as an FTO. The officer was later fired, but the termination was overturned after appeal. We also found incidents where FTOs violated a person's rights while training a new officer. In an October 2017 incident, an FTO and recruit were transporting a 15-year-old teen to a detention center, and the FTO told the teen to remove his shoes so the recruit could search them. The FTO then told the recruit not to return the shoes to make it more difficult for the teen to leave the detention center, an unlawful seizure, with no legitimate law enforcement purpose. In a separate incident in 2020, an FTO used a taser to drive-stun a man 8 times in 30 seconds, not assessing the need for force between each drive-stun. See pages 17 and 28. Ensuring that FTOs teach right from wrong is essential to ensuring that recruits abide by the policies and values of MPD. C. MPD does not adequately supervise officers. Robust supervision of officers is essential to safe and effective policing. Sergeants, the first-line supervisors in a police agency, play a crucial role. Sergeants serve as mentors, respond in the field to uses of force, and ensure officers comply with the law and policy. Sergeants often set the tone at the precinct level. They brief officers daily, conveying organizational changes, enforcement, priorities, and community concerns in their precincts. Supervisors at all levels have a role in enforcing policies and upholding standards among their subordinates. Supervisors who fail to do so should be held accountable for misconduct and performance deficiencies. Supervision at MPD is inadequate for several reasons. First, MPD inadequately trains its supervisors. MPD supervisors, in turn, struggle to understand policy and effectively communicate changes to officers. Second, MPD does not empower supervisors with tools and data that could reveal problems needing prompt corrective action. Accordingly, supervisors do not perform tasks that other agencies commonly require to improve officer performance. Third, staffing practices at MPD inhibit good supervision. MPD's scheduling system prevents officers from having a consistent supervisor, and its secondary employment, or off-duty employment, system undermines supervisory authority. 1. MPD does not prepare officers to be effective supervisors. MPD does not train supervisors effectively to guide and supervise officers. MPD does not provide adequate specialized police training in how to review a force incident. Several sergeants confirmed to us that they did not receive specialized supervisory training in force review. We heard from a supervisor who felt MPD's training for supervisors did not prepare them to review a force incident or a critical incident. Instead, MPD leaves sergeants to learn on the street how to assess whether force complies with policy. MPD also does not support supervisors in preparing officers to understand changes in MPD policy. Clear policies that are consistently enforced ensure good order. But MPD policies often confuse officers. They are cumbersome and difficult to navigate. Sometimes, MPD issues new policies and delays training officers on them, leaving it to supervisors to explain the policies to officers. That process often fails in practice. As one MPD commander explained, it is insufficient to just send an email with a 60-plus page document and expect people to understand it. 2. MPD does not provide supervisors with the tools and data to prevent, detect, and correct problematic officer behavior. Functional police agencies require that first-line supervisors stay informed about the activities of officers and review their reports to ensure compliance with policy and the law. Prompt, accurate reporting of officer activity facilitates effective supervision. Well-run agencies also require sergeants to review reports on stops, searches, and arrests, and to actively supervise officers to guide their enforcement efforts in the field. However, MPD does not require officers to file a police report for all stops or searches. For many stops, instead of filling out a police report, officers use a CAD form, which lacks useful detail. And an officer need not record the fact or nature of some encounters with the public at all. MPD gives sergeants no specifically expressed role in reviewing investigatory stops or traffic stops unless there is a use of force. Without clear, complete, consistent documentation, supervisors cannot meaningfully review police actions. The result is that supervisors cannot identify and address trends or problematic conduct, such as unlawful or improper stops, racial profiling, harassment, theft, and sexual misconduct. MPD can and should collect and use this data consistently for organizational improvement. Data analysis can, for example, help decision-makers assess whether enforcement strategies are reducing crime, improving public safety, or disparately impacting specific groups. MPD could use search-related data to determine how often a search leads to guns or other contraband. If certain types of searches frequently find nothing criminal, MPD could explore whether to train officers to use different indicia of probable cause to justify a search. But MPD cannot learn in this way when officers are not required to complete police reports for searches unless they result in an arrest. MPD's failure to collect and use data about meaningful police activity seriously impedes effective supervision and prevents MPD from operating as a learning organization. MPD also underuses body-worn cameras, BWCs, to improve performance. BWCs are a vital supervisory tool. BWC footage may reveal problems that would otherwise go undetected, such as dangerous tactics, policy violations, including failure to activate the BWC, ineffective de-escalation, or mistreatment of community members. Supervisors should routinely check BWC footage of officers they supervise. But MPD does not require patrol supervisors to review BWC footage other than in connection with use of force reports. Instead, a two-person group of analysts conducts random audits of BWC footage for the entire department. 93 MPD also lacks a functional early intervention system, EYES. EYES is a data-based supervision tool to identify as soon as possible those officers who may benefit from supervisory counseling. Once an officer has tripped certain objective indicators, such as a number of complaints or force incidents, an effective EYES should flag the officer so the supervisor can intervene to help the officer. In October 2021, the city received a $500,000 grant to begin developing an EYES, but work was stalled until recently. 3. MPD's staffing practices further undermine supervision. Effective supervision requires unity of command, meaning that the same sergeant consistently supervises the same officers. Unity of command enables sergeants to develop deeper relationships with the officers under their commands. That familiarity. 93 MPD recently began a pilot to require sergeants to check in with officers monthly and view at least 3 of the officers' videos. This is a positive step. Allows sergeants to more effectively supervise officers. Officers, in turn, can perform better when subject to consistent management styles and expectations. MPD staffing practices undermine effective supervision. MPD allows officers to select their work schedules even if it results in a disunity of command. Every 4 weeks, MPD officers choose the days and shifts they prefer to work. Because officer preferences can vary, officers do not have an assigned sergeant. As one high-ranking supervisor put it, this system is akin to tacking a bunch of names and throwing them into the air, and whatever it lands, that's who the supervisor isn't where they are working. MPD's scheduling approach inhibits sergeants from developing mentoring relationships with officers and makes it more difficult for sergeants to address officer problems. Off-duty employment also undermines supervision at MPD. Private entities can hire off-duty MPD officers to provide security. In Minneapolis, these jobs can pay significantly more than overtime at MPD, up to $150 to $175 per hour, according to a commander. MPD allows officers to use its squad cars and gas, and the officer keeps all the compensation. The city gets nothing. Some patrol officers manage these opportunities, deciding who gets the lucrative work. Because MPD allows patrol officers to control whether supervisors get off-duty employment opportunities, supervisors have ample disincentive to hold officers accountable. MPD's off-duty employment practices impede effective supervision. D. MPD wellness programs insufficiently support officers. Policing, by its nature, can take a toll on the psychological and emotional health of officers. Officers encounter stressful situations, see people in their worst moments, and witness tragic events, including deaths. At times, they face long hours and uncertain conditions. And officers face public criticism about the profession and scrutiny around how they do their jobs. As one MPD sergeant told us, if officers are sick, community members will suffer. Without appropriate support, these factors can affect behavior, influence decision-making and judgment, and lead to stress and burnout, resulting in officers having a diminished ability to serve the community in the way it deserves. 94 We heard from some officers that they felt inadequately supported. The importance of practices and programs to support officer resilience and help officers cope with challenging situations has long been recognized. However, resources for 94 Deborah L. Spence, Melissa Fox, Gilbert C. Moore, Sarah A. Steele, and Nazmia E. A. Kamari, Law Enforcement Mental Health and Wellness Act, Report to Congress, U.S. Department of Justice, Community-Oriented Policing Services, March 2019, https://cops.sdodge.gov/publications/cops b370pub.pdf, https://perma.cc/p7unpr2. Officer wellness have not been sufficiently prioritized at MPD. MPD leaders almost universally recognize the need to better prioritize the health and wellness of officers, but they told us the resources currently available to MPD officers, including a peer-to-peer program and a counselor's support program accessible through a mobile application, were inadequate. Failing to provide adequate officer support has real consequences. Just before George Floyd's murder, only 2.1% of sworn employees were on continuous leave. By the end of 2020, that number had grown to 18.6%. Similarly, the city paid out huge sums for MPD workers' compensation claims for post-traumatic stress disorder. For injuries claimed in 2020 alone, for example, the city paid over $27 million. Officers need support, and failing to provide it carries enormous psychological, physical, professional, and financial costs. MPD has taken initial steps to better address this issue. As of May 2023, MPD reported that it had developed a wellness program and a partnership with an external provider of certain psychological and other wellness-related services, in addition to its peer support network, wellness app, and various debriefings after a traumatic event. It remains unclear, however, to what extent those services are helping officers and affecting the conduct we observed during our investigation. Given the considerable challenges of the last several years in the Minneapolis community, from the COVID-19 pandemic to the widespread trauma and unrest following George Floyd's tragic murder, providing officers with emotional and psychological support is important to ensure that officer stress and fatigue do not contribute to constitutional violations. Recommended remedial measures. We commend the city and MPD for beginning the hard work ahead necessary to make improvements. The remedial measures we recommend below provide a foundation for changes that the city and MPD must make to improve public safety, build the trust of the Minneapolis community, and comply with the Constitution and federal law. Use of Force 1. Improve use of force policies, reporting, and review procedures to minimize the use of force. Revise force policies to emphasize avoiding force and increasing de-escalation and require officers to consider less intrusive alternatives before employing force. Implement force reporting and review systems to ensure that officers report all uses of force and that MPD conducts timely, thorough force reviews. Ensure that supervisors' performance reviews evaluate the quality of their force reviews. 2. Improve use of force training. Provide clear guidance to officers about when it is appropriate to use different force options, including scenario-based training and testing that reinforces these concepts. Stress the importance of the duty to intervene to prevent force and the duty to render medical aid. 3. Enhance force-related accountability mechanisms. Require supervisors to conduct use of force supervisory reviews and identify violations of policy or law. Ensure that supervisors promptly refer evidence indicating misconduct or criminal conduct to the appropriate investigative unit or agency. Take appropriate corrective or disciplinary action when officers violate force policies. 4. Improve data collection and assessment of force. Assess data to identify trends and develop policies, training, and recommendations to reduce the use of force. Ensure that supervisors and command can effectively review force data. 5. Develop force policies appropriate for youth and people with behavioral health needs. Recognize the unique characteristics of youth and people who have behavioral health needs. Develop policies addressing those characteristics. Identifying and reducing racial disparities. 6. Improve documentation of police activity. Ensure public safety data collection allows for analysis of racial disparities, including for stops, searches, search warrant applications, warrant executions, citations, arrests, force, and investigative activities. Ensure data captures the basis for enforcement action, including reasonable articulable suspicion or probable cause for stops and searches, the basis for consent searches, and the results of each search. Differentiate between traffic and pedestrian stops. 7. Analyze data from enforcement activity. Develop capacity to analyze data about racial disparities in enforcement activities overall, and to assess the impact of any specialized units, initiatives, or programs. 8. Reduce unjustified disparities. Where unjustified racial disparities exist, take steps to reduce or eliminate them within MPD. Protecting First Amendment rights. 9. Improve policies and training related to protests and demonstrations. Revise policies on responding to civil disturbances and disorderly conduct to improve planning for protests. Emphasize First Amendment freedoms, protect the right to gather and report the news, limit the use of less lethal weapons, and provide daily after-action reports about force, officer wellness, and effectiveness. Training should address the challenges of protecting public safety and First Amendment rights during demonstrations critical of law enforcement. 10. Improve accountability for First Amendment violations. Ensure that force reviews and reviews of misconduct complaints assess whether an officer's conduct violated the First Amendment. Develop an after-action review process following protests to evaluate the performance of officers and commanders. Responding to people with behavioral health issues. 11. Expand BCR's capacity, training, and coordination. BCR should become a permanent 24/7 program with appropriate capacity, clinical oversight, comprehensive training, and continuous quality improvement processes, including enhanced data collection and reporting capabilities. BCR should develop relationships with COPE and other mental health services to better serve individuals experiencing behavioral health issues, and BCR should cross-train with MEC, MPD, EMS, and fire. 12. Ensure MEC is dispatching appropriate responders. MEC should work closely with BCR, MPD, fire, and EMS to update protocols for calls for service involving behavioral health issues. MEC must also coordinate with first responders, as well as city and Hennepin County entities, around the recent launch of the 988 Suicide and Crisis Lifeline. Prioritize MEC staffing issues, training on calls involving behavioral health, and quality assurance processes to assess call taking, dispatches, and responses to such calls. 13. Develop and implement appropriate policies and training relating to behavioral health and assess their impact. Provide clinically informed training including community perspectives for MPD officers and supervisors. Develop policies and training specific to youth experiencing behavioral health issues. Ensure trainings address coordinating responses with other key actors, EMS, BCR, and COPE, avoid topics such as excited delirium, and ensure oversight of such training material and presentations. Implement after-action reviews of calls involving behavioral health issues, including debriefings for system and officer improvement. Accountability. 14. Identify, address, and document all allegations raised in misconduct complaints. Ensure all allegations of misconduct are comprehensively reviewed and resolved with appropriate documentation explaining decision-making. Hold supervisors accountable for failing to report or address misconduct. 15. Require officers to report misconduct. Where officers do not report known misconduct, ensure they are held accountable. Ensure protections against retaliation for officers who report the misconduct of other officers. 16. Facilitate civilians' access to the complaint process. Ensure that when any officer encounters a person who wants to make a complaint, the officer puts the person in contact with a supervisor, internal affairs, OPCR, or otherwise enables them to complain through appropriate means. Provide training to all officers on the appropriate procedures and on reasons for facilitating civilian complaints. 17. Improve civilian complaint investigations. Ensure that when people make an allegation of MPD misconduct to any member of OPCR, MPD, or a city employee, the allegation is documented and reviewed, the allegation is fully investigated consistent with the Minneapolis Code of Ordinances Section 172.30, amended December 14, 2022, and state law, and the complainant is kept up to date on the complaint status. Train OPCR and MPD internal affairs investigators on investigative practices and the particular challenges of police investigations. 18. Fully staff OPCR and MPD internal affairs units. Ensure that OPCR and MPD internal affairs units are fully staffed with enough qualified, Will train investigators to complete all investigations in a timely and consistent manner, ensure that investigations are thorough, interviews are conducted appropriately, all evidence is appropriately weighed, and sound determinations of credibility of witnesses are made where there is conflicting evidence. 19. Improve the review process for OPCR and MPD internal affairs investigations. Streamline the review process for administrative investigations to facilitate their timely resolution. Establish time limits for each stage of review, set firm expectations to ensure the process moves forward expeditiously, and document all decisions. 20. Improve quality of data and civilian oversight. Cooperate with the Community Commission on Police Oversight to promote robust and even-handed civilian oversight. Prioritize transparency in its internal affairs practices, including reporting to the public about the nature of complaints received, misconduct findings made, and discipline imposed. Ensure IA and OPCR cases can be easily linked with police files. Transparency 21. Ensure accuracy of public statements. Ensure city and MPD leaders provide timely, accurate information about public safety, including after critical incidents. Supervision 22. Require consistent activation, deactivation, and review of body-worn cameras. Require officers to consistently activate body-worn cameras to document interactions with the public. Require supervisors to review footage to monitor officer performance and ensure compliance with MPD policies. 23. Require review of all stops. Require supervisory review of the reasonable articulable suspicion for any stops and frisks, the probable cause of any searches, and the basis for any consent searches. Require periodic analysis of the efficacy of certain practices where officers have more discretion, such as pretext stops or consent searches. 24. Revise staffing practices. Ensure that staffing practices achieve unity of command and that off-duty employment policies are consistent with officer wellness and effective supervision. Train supervisors to improve force incident review and to better communicate policy changes to officers. Training 25. Improve training department-wide. Use qualified instructors, best practices in adult learning, and outside experts and community-based instructors. Involve training officials in after-action evaluations of force incidents. 26. Improve training for supervisors. Train supervisors to promote effective and constitutional police practices by leading subordinates, monitoring and assessing their performance, evaluating written reports, investigating uses of force, building community partnerships, and de-escalating conflicts. 27. Reform the Field Training Officer Program. Improve standards for training and selection of field training officers so that they will consistently model and support MPD values and standards. Standardize the Field Training Officer Program to ensure all officers and recruits are evaluated consistently and fairly. Wellness 28. Ensure effectiveness of health and wellness programs. Ensure that officers are accessing effective support services and develop a comprehensive early intervention system to establish support for officers who need it. Conclusion: the Department of Justice has reasonable cause to believe that MPD and the city engage in a pattern or practice of conduct that deprives people of their rights under the Constitution and federal law. MPD uses unreasonable force, infringes on First Amendment rights, and discriminates based on race and disability. MPD also lacks the systemic safeguards that can prevent or address those abuses, such as effective accountability, rigorous training, robust supervision, and appropriate officer support. City and MPD leadership have been forthcoming about the need for reform. We recognize that they have negotiated a proposed settlement agreement in order with MDHR that includes comprehensive reforms. We hope the remedial measures we propose will be the foundation for a productive conversation with the city and the Minneapolis community about the future of public safety.